friends, welcome to the National Constitution Center and happy Constitution Day. It's so wonderful to be back in person here at the center and to celebrate for us the most exciting and inspiring day of the year, which is to mark September 17th is the day that the Constitutional Convention proposed a constitution right over there in Independence Hall. We're so honored to have three distinguished judges from the courthouse right across the street help us think about how to interpret the Constitution. Friends, just this week, the Constitution Center is launching a new set of Constitution 101 videos that basically teach you how to think like constitutional lawyers and to interpret the Constitution the way judges do. And to do that, you have to learn about the methods that judges use to interpret the Constitution. Now, these are the kind of things that law students learn when they go to law school. I'm a law professor, and when I teach constitutional law, I teach about these methodologies. Now, you're not in law school, but you have the same opportunity to read Supreme Court opinions and to figure out how judges and justices are interpreting the Constitution as anyone else does. So in this talk today, we're going to do something that is really illuminating, which is to help, the judges are going to help us walk through the different methods that they use to interpret the Constitution, and that'll help you understand these Supreme Court opinions. Now, there are 7 of these methods, and I'm going to tell you what they are, and then each of our judges is going to give you an example of a Supreme Court opinion applying that method of interpretation. So you'll understand it, and then we'll maybe have the chance to ask them some questions. So here are the methods: text, history, tradition. I always think of that Fiddler on the Roof song when I hear tradition. Precedent, structure, prudence, and arguments about morality or natural law. That's a lot to kind of present you with all at once. 7 methodologies: text, history, tradition, precedent, structure, prudence, and natural law. Let's run through them and see what our judges say about how to apply them. And just to pull back for 1 second before we dive into these methods, there's a vigorous debate in America right now about how to interpret the Constitution. And when you read Supreme Court opinions, you'll find some of the justices saying that methods that focus more on text, history, and tradition are the most important thing. Some of those justices call themselves originalists, or judges who care about the original understanding of the Constitution. And then there are judges on the other side of some of these opinions who think that other factors are important, like what judges have said before: previous precedents, or the practical consequences of decisions, or arguments about morality. Those judges don't always have a label, but sometimes they're more open to an idea of a living Constitution. And you'll find strong disagreements on the Supreme Court in those really important cases about which method to use. And these are the cases involving the ones in the headlines: guns and reproductive choice and religion, all the things that people really fight vigorously about. What I'm telling you is you can't make up your mind about which side in those decisions you think is right until you've learned the different methods that the judges are applying, and pick for yourselves which ones you find most persuasive. And that's why it's kind of an experiment to this. We're really lucky to have, these are among the most respected and distinguished judges in America. They're going to walk us through these methodologies. I know it's a lot to present you with all at once, but I have faith that you can follow it because they're going to be so good in explaining. Okay, so here we go. Our first method is text, and a judge who cares about the constitutional text looks at the meaning of the words in the Constitution, relying on the common understanding of what the words meant at the time the provision was added. And to help us understand textual approaches, we're lucky to have Judge Rendell, and she's going to tell us about District of Columbia versus Heller.
Thank you, Jeff. Yes, this case involved restrictions on the possession of guns, and the Supreme Court struck down those restrictions, looking at the Second Amendment. So we look at the text of the Second Amendment and say, what does it really mean? Okay, and I'll read you the text. a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So what does that mean? Well, the right to bear arms. There was a disagreement in the Supreme Court. Justice Scalia said bear arms isn't restricted to just wartime. Justice Stevens said bear arms is restricted to militia. So obviously, it's just about militia, not about the right of people to have arms in their home. Well, Justice Scalia had the majority, and that's why those restrictions were struck down. But another interesting aspect of the opinion in the text is the disagreement about what the beginning, they call it the prefatory phrase, means. It says, a well-regulated militia being necessary to the security of a free state. Okay, does that mean, as Justice Stevens in the dissent said, that there was a single-minded focus on military use? But Justice Scalia said, no, the idea is if you weren't allowed to have guns in your home, then when the militia was called together, nobody would have the guns to form the militia. So seriously, that's what it means. So there's this disagreement about the text. Now, when we look at the text in the Constitution, very often we have to revert to history because, as Jeff said, look at what the words meant at the time the provision was added. So textually, the Constitution doesn't tell us a whole lot until we do look at history and figure out what they meant. So I think it's kind of it's a mixed bag, if you will. Now, when we're looking at statutes, text is much more important. We look at the text, we look at other provisions or section of a law. It's much more informative. But I would say that the Constitution text ends up being very much aligned with history.
So interesting and such a great introduction to textualism. You heard what the judge said. The court was disagreeing about the meaning of the words keep and bear arms as citizens do. But the judge said, in the end, the court couldn't decide purely by looking at the words. She also had to look at the history about the words in context. And that leads to our second methodology, and that is history. And history, which involves looking at the original meaning or original understanding of the Constitution, asks a judge to look at the historical context of when a given provision was drafted and ratified to shed light on its meaning. And to give us an example of a case that applies history, Judge Bibas is going to tell us about Crawford versus Washington.
All right. Thank you, Mr. Rosen. So there was a fight between two men, and one of them stabbed the other one. Now, the stabber said, I was defending myself. I thought the guy might have been reaching for something. He might have had something in his hand. Now, the defendant's wife, though, when the police had interviewed her, had said, I didn't see anything in the victim's hand. Now, you can't make a wife testify against her husband if she doesn't want to. So they couldn't make her come to trial and repeat that. So instead, the prosecutors tried to use what she had said to the police to help convict her own husband. And the husband said, hey, wait a second. There's a constitutional provision that governs this, the Confrontation Clause of the Sixth Amendment. And it says, in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. So does that forbid using the out-of-court statement of his wife to convict the man to say, no, he can't claim self-defense? So the court started with the text, and it said, look, we look at the words, but they don't answer this question because you could read witnesses against just to mean the person who's in court, or it could also mean people who are out of court who say something. So we have to go beyond the text to figure out which of these it means. They looked at history. They went all the way back to Roman times and said, since the Roman times, there's been an understanding of some kind of right to confront your accuser. If you're the defendant, you know who it is who's saying you're guilty of a crime. Now, England had a very different approach to criminal cases from continental Europe. England had this Anglo-American common law approach involves live witnesses in court, facing face to face. So the witness says his story in front of the jury. The defendant is face to face and can then cross-examine the witness who's right there in front of the jury, not using hearsay that was said out of court. Now, On continental Europe, they had a different approach. The civil law system says it's okay to do interviews, depositions, and things out of court and just read the statement in court. England deviated a little bit from this sometimes. There were some politicized times in England and some treason trials. There was a man, Sir Walter Raleigh. He was charged with treason. They had the person he supposedly worked with, they had a letter from him, some interview he gave out of court, and he said, bring him into court. I want to question him. The jury's going to see that he was forced to make this up, and he'll take back his story. They didn't. And so he wound up being condemned to death. Well, the American colonies in England and then the American colonies saw this was an injustice. We're not going to allow this. And so they enacted the confrontation clause to make sure there would be live face-to-face confrontation. And so you generally can't use an out-of-court statement that was meant to prosecute or convict somebody. You have to bring the person into court. And so it's connected with this idea that you can't use hearsay as a way around live witnesses.
That's so interesting. Isn't it fascinating to hear the judge describe the history so clearly and so well? And part of the excitement of studying the Constitution is you get to learn all this history. And he described the difference between the Roman and the English approaches. And the bottom line of that case that he described so well is the Supreme Court said, yes, if you don't have the chance to confront your accuser live, then the accusation can't come in. And that was an example of using the original understanding of the Constitution to favor the rights of the accused. We have 7 methodologies, so I'm going to ask Judge Bibas to do one more so that we get through our rounds. And the next methodology is tradition. And for tradition, a judge looks to any laws, customs, and practices established after the framing and ratification of a given provision. So if the history approach says, what did the framers think at the time the provision was ratified? That's 1788 for the Constitution, 1868 for the 14th Amendment. The tradition approach looks to a kind of wide-angle lens of what the traditions of our people have been throughout the whole scope of American history. And for a tradition-based case, Judge Bibas, you're going to tell us about American Legion versus American Humanist Association.
Sure. So the Constitution's First Amendment has an establishment clause. It says Congress shall not pass any law respecting any establishment of religion. And after the 14th Amendment, the Bill of Rights also applies to state governments. So there was World War I, and a lot of American soldiers died. In the years after World War I, the state of Maryland, some people in Maryland put up and then gave to the state this large 40-foot cross. It wound up being in the middle of a traffic circle in Bladensburg. It was dedicated to World War I veterans. It had the names of a bunch of veterans who had died. And so the question is, if the state government owns and allows to remain this large cross, does that count as an establishment of religion? So there are arguments. Should they take the cross down? Should they chop off the arms of the cross or do something to it? And the Supreme Court said, no, it's fine for the state government to preserve an existing monument like this. And so they looked at 2 different kinds of tradition. The first kind is, what is the tradition since the Establishment Clause was enacted of allowing public expression of religion? And they noticed there's a lot of things in American life that have some connection. You look at coins in your pocket, they say, in God we trust. You look at town names, there's Bethlehem, Pennsylvania, there's Corpus Christi, Texas. All of those are well established and they have religious origins, but they actually mean more than that, and you don't have to get rid of all of those. There are crosses on flags like Maryland's state flag. There are monuments to the 10 Commandments. Indeed, in the Supreme Court's own courtroom, they've got Moses with the 10 Commandments as a famous lawgiver in history. There are statues of religious figures like Martin Luther King. And there's a long history at the start of congressional sessions of having chaplains offer legislative prayer. So the Establishment Clause can't mean that you have to keep all of these symbols out of the public square. So then the court turned specifically, what do we make of these monuments, these cross monuments that have been around a long time? They've been in cemeteries like Arlington National Cemetery. You've got this cross. And the court said, well, tradition does something also to how we understand old monuments and symbols. It obscures the original purpose. The cross, of course, is Christian, but it's not just an object of worship here. There are overlapping purposes of remembering the war dead and their sacrifice. It changes the effect of the monument as it becomes embedded in a community. When you see a cross in a cemetery, you're not thinking of worship. When you see a Star of David on a Holocaust memorial, you're not thinking that this is a place for prayer. It's a remembrance of the people who suffered. It's not in a worship context. And it makes, if the government were to take this established thing that has a bunch of meanings on it and then removed it, the government might look like it was hostile to religion. So the court was careful to say, we're not talking about putting up new monuments, but these long existing monuments, the tradition has changed and developed their meaning such that they're kind of embedded, and the government is not establishing religion by allowing it to remain.
So interesting. Friends, you're getting a graduate level course in constitutional law with these wonderful examples, but it's so fascinating to hear these judges give such a good example of the tradition-based approach. And you heard what the judge just said. Maryland's allowed to keep up that monument with a huge cross in the middle of the town because there've been crosses in public up for a long time that haven't had the meaning of trying to persuade people to follow one religion or another. So the mere fact that a tradition has persevered over a long period of time is a good guide to its meaning. Our next methodology is precedent. And precedents are the decisions that previous courts have said about a particular case. And in following precedents, judges are guided by something called stare decisis, or let the decision stand. And Judge Krause is going to tell us about the Gamble versus United States case as an example of a precedent-based approach.
So stare decisis, or this idea of precedent, is something that you've probably all heard a lot about recently, because of course it's come up in terms of whether the precedent of Roe v. Wade should stand, and that was recently overruled by the Dobbs case of the Supreme Court. That concept, stare decisis, as Mr. Rosen said, means to stand by things decided. And the idea of stare decisis is that it's a way of following what judges have said before. And it doesn't mean that we do that without exception or without re-examining whether a decision that came before was correct. But it does mean that that's a guiding principle and one of the main ways that we go about interpreting the Constitution. Where it comes to the structures of our courts, the lower courts, including our court, which is a court of appeals, and the district courts, the trial courts at the federal level, we all have to follow the precedent of the US Supreme Court. We can't do something different than the US Supreme Court has told us to do if it's squarely applicable. But the US Supreme Court can, and sometimes does, revisit its old precedent. It has recognized that while it is oftentimes, it is more important to have a point that is settled than be right. When it comes to the Constitution, the Supreme Court has said it's very important that we be right in a case where it's a constitutional case in particular. Why? Because the US Constitution is extremely hard to amend. And the only ways to change a US Supreme Court decision, if the court has interpreted the Constitution a certain way, is either to amend the Constitution or for the Supreme Court itself to revisit a decision that it's decided is wrong. And even when there is precedent that is long-standing of the Supreme Court, people will come occasionally and ask the court to reconsider that precedent. So the case of Gamble is one where, although there had been a long-standing precedent in terms of the interpretation of the Fifth Amendment, the bar against double jeopardy, a litigant decided to challenge the court's interpretation of that. Now, in particular, the Fifth Amendment says that no person will be subject for the same offense to be twice put in jeopardy of life or limb. And the Supreme Court for over 100 years had held that while that means the same offense, the Supreme Court had long said that where it's been a conviction, an offense that was charged and tried before a different sovereign, a different government, that a second prosecution did not mean that you were being put in jeopardy for a second offense. It was a different offense because it was from a different sovereign. What does that mean in practical terms? Well, we have different sovereigns that govern us, right? We've got, we're citizens of our states, and we're also citizens of the United States. So what this precedent had meant over 170 years was that when the federal government had charged someone and convicted someone of an offense, the state could still go ahead and charge them and convict them of the same offense, but under state law instead of federal law. What happened in Gamble was that there had already been a conviction under state law. And this was, Campbell had committed a robbery and in Alabama, and he had with him a firearm. Under Alabama law, it's a crime to possess a firearm if you've already been convicted of an offense. And so he was charged and convicted and sentenced under Alabama law. But then the federal law enforcement and the federal prosecutors decided that they would also charge him under federal law. And given the court's longstanding precedent, that was allowed. So he was tried, convicted, and sentenced to an additional prison time under federal law. And he appealed all the way through to the US Supreme Court, arguing that that precedent was unconstitutional, that it was time for the US Supreme Court to go and revisit its prior decisions and to reconsider whether where there's conduct that's led to charges by the state government versus federal government, those should both be allowed to proceed, or whether that was a violation of his rights not to be put in jeopardy 2 times. Now, when there's longstanding precedent like that, as you might imagine, you have to come up with some pretty good arguments to persuade the court. So he tried a number of things to say, well, times have changed. So, for example, now there are a lot of state offenses that resemble those of the federal government. And since there are so many that are the same, not like it used to be hundreds of years ago, the court ought to reconsider so that you don't have someone who is just routinely going to be charged and sentenced by 2 different governments. He argued that the court's earlier precedents had been before incorporation, that is, before the US Constitution and concepts of double jeopardy had been applied as against the states with the incorporation through the 14th Amendment. So he said that changed things, and the court ought to revisit now that the federal Constitution applies to the states, the Bill of Rights is applying to the states. Now you shouldn't allow this to go forward. The court went through all of those arguments and ultimately concluded that 170 years of precedent should stand. Why? It wasn't persuaded that the decision was so very wrong, or that the reasoning of that decision was mistaken. And those are a couple of the things that the court over time has identified as factors in considering when precedent should be overruled. The court in the Dobbs decision most recently gave a really excellent summary about precedent, the purposes it serves, and also the criteria it uses in thinking about when to overrule precedent. And I just wanted to very quickly go through those with you. So when you think about applying precedent to interpretation of the Constitution, you have these ideas in mind. What's the purpose of stare decisis? Well, it protects the interests of those who acted in reliance on it. It reduces the incentives for needless relitigation. It fosters even-handed decision-making because it requires that like cases be decided in a like way. And it restrains judges and reminds us to respect the decisions of those who have come before. But because it is, as I mentioned before, so hard to amend the Constitution, the Supreme Court in particular will re-examine. And when will it re-examine? It will consider the nature of the error. How fundamental does it think the error is? It'll look at the quality of the reasoning for the original decision it's considering overruling, the workability of those rules that the prior precedent imposed, the disruptive effect that the prior precedent may have had on the law, and whether there are concrete reliance interests, whether people have set about their lives and structured their lives relying on that precedent, or perhaps not so much. Those were considerations that they brought to bear in Gamble. Those were also the very considerations that they lay out in considering Dobbs and whether to overrule most recently Roe v. Wade.
Wow, bravo. That was just a superb distillation of the principles that courts apply in precedents. I have to say, Judge Krause's dad is watching online, and you should be very proud of Judge Krause for having summed up the basic ideas of precedent so clearly. And I can't say it better than she had, but you just got a mini course about the factors that the court uses in deciding whether to overturn a precedent. She just reminded us what the ones were in the Dobbs case, the quality of the reasoning, the nature of the error, the workability of the test, the effects on other areas of law, and the reliance interest, whether people have structured their lives around them. And she just gave these two great examples. One, this double jeopardy case where the court decided not to overturn this really important precedent. And then she mentioned the Dobbs case, which is that one that was, the country is so focused on, where just last June, the court overturned Roe v. Wade, applying those very factors. Thank you so much, Judge Krause, for teaching us about precedent. Speaking of the Dobbs case, our next methodology is natural law and morality. And in cases where judges apply these factors, they look to questions like, is the right rooted in understandings of moral philosophy or in natural rights that come from God or nature and not from government? And to give examples of natural law-based reasoning, Judge Rendell is going to tell us, well, these are two big cases. One is Obergefell and Hodges, which involved marriage equality for gay people. And the other was Planned Parenthood v. Casey, where the court in 1992 affirmed Roe v. Wade.
Yeah, and let me start with Obergefell, the gay marriage case. So you're a Supreme Court justice, and someone wants to say that the Constitution protects gay marriage. You kind of scratch your head a little bit, because where are we going to find this? The text doesn't really do it. History doesn't do it. Gay marriage is, I'm sure it's been around for a while, but it's a very recent phenomenon to be prevalent. What are we going to do? Where are we going to find the right to gay marriage? Well, Justice Kennedy, and I have to put in a little plug here, both of my colleagues here clerked for Justice Anthony Kennedy, which is huge. So I really shouldn't be talking about these cases. They know Justice Kennedy far better than I. But he rooted this decision in essentially morality. And he said, the plea of someone wanting to marry a gay person is that they do respect it so deeply that they seek to find its fulfillment, that is, the fulfillment of marriage, for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right. So he based it on principles of morality individual freedom and the idea that if the individual prospers, so does society. Now, there were a lot of dissents to this opinion. And the Chief Justice accused Justice Kennedy of changing the definition of marriage. It always had been thought of between a man and a woman, and it always had been regulated by the states. So this was a big step. But he also accused him of performing an act of will and not a legal judgment. But the majority felt this is part of what society is today. This is a moral imperative. The dissent said it isn't based in the Constitution. You can't find it there. And we're not going to go along. But the majority won in that case. Now, the Casey case was a follow-on to Roe v. Wade. And it essentially changed the reasoning and found that there can be no law that places an undue burden on a woman. And whereas Roe v. Wade was written a lot about privacy, Justice O'Connor, in writing the Planned Parenthood versus Casey, talked about liberty and talked about a woman's right. And I'll just read you some of the language. She said, "These matters involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state." So she's finding individual liberty and autonomy, which is in the 14th Amendment, but expanding that to be more of a moral imperative rather than a legal imperative of, we think of liberty as, if you're convicted, you have a right to bail, you have a right to do certain things, but she's making it extremely personal in a moralistic type of way. And I think these types of cases, gay marriage, abortion, where can you really go back to the founding fathers? Well, in Dobbs, they did. There was a historical analysis in the Dobbs case, although both sides, both the majority and the dissent, found history to help them in different ways. But in these cases, Obergefell and Casey, they didn't do that. They said, we're modern day people. This is the way we live and breathe. This is our own personal autonomy. We're not going to be tied to what happened in colonial times. We're going to recognize the rights of people to determine their own fate. So they're very much these social cases that come up. And there's some question about whether Obergefell would be decided the same way and whether gay marriage would survive under a historical analysis, just like Dobbs, Roe v. Wade fell under a primarily historical analysis. So these differences between a moralistic and a historical analysis is huge.
Beautifully explained and very well put. You heard what the judge said. The difference between the methodologies we're talking about is huge. If you embrace, as the judge said, an approach that cares about questions like morality and natural law, you might favor upholding a right to choose abortion or a right to gay marriage. If you prefer a more historical approach or one based in text, history, and tradition, you might, as the Dobbs court did, overturn Roe and say there's no right to a reproductive choice. And the judge properly noted that in the Dobbs case, Justice Thomas suggested that he might overturn marriage equality because he's more focused on text, history, and tradition than about natural law and morality. So you see why we're presenting you these methodologies. You got to understand them and decide what you think about them. And in order to pick the ones you find most persuasive, and your choice is going to have huge implications about whether you think the Constitution does or doesn't protect rights like abortion, marriage equality, and all the other rights that we're talking about. Okay, we've got two more methodologies, and our next one, second to last, is structure. And Judge Bibas, what a great case you're going to tell us about, and that is the Steele seizure case. What was going on then?
All right, so let's back up. The first three methods we talked about, text, history, and tradition, are about specific phrases in the Constitution. But now, with morality and policy and structure and precedent, we're talking more generally about how do you read the Constitution more as a whole. So the steel seizure case is about something called the separation of powers. The Youngstown Sheet and Tube versus Sawyer arises during the Korean War. So 1950s, America is supporting South Korea, President Truman, there's inflation happening because of the war. The president wants to stop the inflation, but he doesn't want to try to cap the prices. He decides, I want to hold down the wages. The steel workers decide then they're going to go on strike. Steel is very important for munitions and the military. Now, there were a couple of laws on the books that say, okay, in some circumstances, the president could take this step and this step or get authorization to seize some goods he needs for the military. And there's another one that says if there's a strike, you're supposed to have some kind of arbitration between the parties. But President Truman doesn't follow those procedures. He says, I'm the president, I've got the power, I'm going to seize the steel factories and keep them open to make sure they keep making the bombs and the tanks and the bullets and things. So the court hears argument in this case, and the argument is not about just an individual phrase in the Constitution. The phrase separation of powers doesn't show up anywhere in the Constitution, but if you look at the first three articles that define the three branches of government, each of them starts with this concept of what is that branch's power. Article 1 starts with all legislative powers herein granted shall be vested in a Congress of the United States. And then Article 2 says the executive power shall be vested in a president of the United States. And Article 3 says the judicial power shall be vested in a Supreme Court and inferior courts. So the question is, what is the executive power? And how does that interact with the legislative power? The framers and people talking around then and the Federalist Papers all talked a lot about what's the role of different branches. And they thought it was important to separate out what Congress does from what the president does from what courts do so that no one branch or no one person becomes a dictator. They didn't want a king. So the court focused in on that there were these laws. You could have gone to Congress and gotten a law. And the court probably would have been a lot more deferential if Congress had said, yes, you can seize the steel factories. You could have taken the existing laws and followed the way they said to do things. You give a period of time and notice under one of the laws Congress already said, but President Truman said that's going to take too long. You could have gone and tried to mediate the strike by the workers, but he didn't want to do that. He wanted to rush ahead. And so the justices concluded that was not enough. And Justice Jackson had a famous concurrence that has been very important and cited by the Supreme Court later. And he says, let's look at it in three baskets. When the president acts together with Congress, then we're going to really strongly presume he can do it. If the federal government can do it at all, then president plus Congress together can probably do it, right? But there's a second possibility. Let's say the president acts and Congress hasn't said anything. Well, in that situation, maybe there's a twilight. Maybe we're not sure either both branches can act, but Congress didn't try to stop it. So there'll be some deference there, maybe not as much as if they worked together. But there's a third category. And this category is if the president does something that conflicts or is incompatible with what Congress said he could do. His power is at his lowest, right? So they said here, there's an important division, and Congress set up and ignore those laws. Same thing when it comes to the power to make war. Article 2 says when there's a war, the president is commander-in-chief of the Army and the Navy. So Truman said, I'm commander-in-chief. I can do anything anywhere that you can do with an Army or Navy. But it's Congress under Article 1 that gets power to declare war. So the court was very careful to say, we're not going to let the president become a dictator or a king. We're not going to let him do something in the face of what Congress said. And so the separation of powers, even though it's not spelled out, when you read across these branches of government, when you read across the 2-3 articles that set up the presidency, that set up the Congress, that set up the judiciary, the president can't do this on his own, especially in the face of what Congress said.
Fascinating. What an amazing case and what a great explanation for what structural interpretation looks like. And as Judge Bibas said, Justice Jackson's concurrence sets out those three categories, and he told us what they were, and let's just repeat them so we have them in our mind. First, when the president is acting with congressional authority, his power is at its zenith. When he's acting in the face of congressional disapproval, his power is at its lowest point. And when Congress hasn't spoken clearly, he's in a zone of twilight. And I always think of the music, do, 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 do. And then it's not clear whether or not he can act. And as Judge Bibas said, that's not spelled out explicitly in the Constitution, but Justice Jackson inferred that by looking at the structural relationship among the branches. And just to hammer home why this is important, everything these judges is telling us about these methods is important. It's structural interpretation that the court may use when it decides things like, can President Trump build the wall when Congress hasn't said clearly that he can? Or can President Biden forgive student debt? All of those questions, those executive orders are going to go up to the court, and they may use structural interpretive principles in deciding whether or not the president can do that. All right, our last methodology is prudence and looking at the pragmatic consequences of a decision. And to explain that, Judge Krause will tell us about Cox versus State of New Hampshire.
So this idea of pragmatism, of the practical consequences of decisions, really it looms large, and it plays a role in all the other methodologies that I think you've been hearing about. We want to make sure, as the third branch, as judges who are not elected and don't answer to the public, we don't answer to constituents out there who can vote us out of office, that we are staying within our bounds. And many of the rules of interpretation that you've been hearing about are designed to help us do that. They are quite formal, and when strictly applied, they can also lead to results that don't necessarily make a lot of sense, depending on how sort of strictly and formally we apply those rules. And at the end of the day, that is a way to think about many of the debates you hear about the Constitution. Do we apply an originalist view that is history is cabining us, and we stay within the confines of the way things were in the 18th century? Or do we think of it as a living constitution that evolves over time and needs to change in its interpretation or applications to address modern day issues? Do we apply precedent very formally and just follow that guidance? Or do we look back and say, maybe things have changed sufficiently that we now think this decision is wrong or needs to be revisited in some way? And when it comes to making sure that our laws are respected by the people, it also has to have the both appearance and reality to the public that these laws are administering order, that they're providing a trust and respect for the rule of law, because that trust and respect is the only thing that allows for enforcement of decisions that are actually being made by judges. We don't have, like the executive branch, we don't have a police force that goes out and enforces decisions. Our decisions and the rule of law in this country, the way things work, people honoring contracts, the stock exchange is working, free and fair markets. It's because we agree on common principles about abiding by the rule of law. And that ultimately requires that the Constitution, as we think of it, this seminal document that enshrines the meaning of being American, these civil liberties that are there and that have carried from the founding of our country to today, that they not be interpreted only in formal ways, but also with an overlay of things that are practical. How does this actually affect the parties before us? How does it actually affect the country? And it's with many of the rights, things like a right to a due process under law, or concepts of equal protection under law, or free speech, or the right to free exercise of religion. What's in the Constitution is minimal in terms of the words. The court has to do interpreting to come up with rules about how those rights will be applied in particular cases. With many of them, they've done that by coming up with tests that allow for a balancing of a number of different factors. This case, Cox versus State of New Hampshire, is a great example of that. It was one where in New Hampshire, in the city of Manchester, a religious group, Jehovah's Witnesses, went out and they wanted to go and walk through the streets, marching, essentially having a parade through a number of different public streets and sidewalks. So what's the problem with that? Sounds like traditional First Amendment, right? You get to go out there in public spaces and express your thoughts. Well, the problem was that there was a license requirement, and that the group had not gone and gotten a license ahead of time. So there were arguments that both sides made about their right to exercise the First Amendment, but on the other hand, the police didn't have advance notice, so they weren't able to take precautions about handling traffic or handling the flow of pedestrians on sidewalks. With the advance notice, because someone had gotten a permit to do that, they could have taken those steps. So when the Jehovah's Witnesses were actually charged criminally, and they challenged this law as unconstitutional. Well, the court considered the interests on both sides and came up with a test that we still use today, thinking about what is, for purposes of the First Amendment, a reasonable time, place, and manner restriction. It said that the government can impose reasonable limits on the time that people express themselves and the locations where they do that, and the ways that they do that. You live with the consequences of things like that every day, of reasonable time, place, and manner restrictions. And Cox versus New Hampshire, that was back in the 1930s that they came up with a test of thinking about reasonable time, place, and manner. But fast forward to something much more recent, something like a big concert in Central Park, where a group wanted to have their own amplification systems, blasting music really loud to have a great concert in Central Park, which had over years had been bothering people in the park that wanted to have quiet, in the area right next to this amphitheater, or the people who lived in the vicinity and didn't want music blasting late at night. And in Word versus Rock Against Racism, much more recently, the court upheld, again, as a reasonable time, place, and manner restriction, a rule that New York had put in place, saying it's got to be our people and our sound system that are dealing with the volume. So what does that mean, a reasonable time, place, and manner? It means that they look to make sure that you're not discriminating with the content, with the kind of speech. It's not what you're talking about. It's not what kind of music. This is a rule that is generally applicable to everyone. And they looked at, well, what's the government interest here? And how close is the regulation? how narrow is it to make sure that it's not affecting other rights, but it is addressing that substantial interest of the state. And then the test says, okay, let's look at what other alternatives there are, how much of the protected right there still is, and are there other ways besides the one that's being restricted that people can exercise that right? So, as you can tell, this has a lot of factors, right? It's a multi-factor kind of test, thinking about balancing out the government's interest, the nature of the restrictions, how much it impairs somebody's ability to exercise their rights. Can they do it somewhere else? Those kinds of things give a court the opportunity in a particular case coming before it to make practical decisions that balance out the needs of society and of individuals. And at the end of the day is the sort of thing that preserves people's trust and faith in our courts, in our Constitution, and in the rule of law that governs our country.
Wow, what a great way of summing up the last methodology and of emphasizing its importance in maintaining the public's trust in the courts. And Judge Krause gave us that powerful First Amendment example of a case where the court was balancing the interests of the government against the interests of the individuals. And she said also that the choice of which methodology to apply might be governed by considerations like how will people trust the courts as a result. And you can keep that in mind as you choose among the methodologies that we've presented you with. Friends, I'm so grateful to our judges for having presented these methodologies so clearly. And this is one of the best introductions to constitutional law I've ever heard, because you had very great judges giving us concrete examples of cases where different judges applied different methods. And now you have the tools to make up your own mind. I want to urge you to keep learning. A bunch of ways to do that here on Constitution Day. At 2 o'clock, right here, we're going to have a debate. Should the Constitution be interpreted in light of its original understanding? And that will pick up on the conversation we just began. And we've got some great journalists and scholars on both sides of that question, arguing about whether text history and tradition should be the main things that judges look at, or whether they should consider the other factors we've been talking about. And then we've just launched this amazing Constitution 101 class that all of you can take online, and that I hope your teachers will think about introducing in the classrooms too. And the very first unit talks about the methodologies. There's a video to remind you about which ones there are, give examples like the judges did, and then just a whole lifetime of learning ahead as you as we learn and grow together. Friends, thank you so much for joining us on Constitution Day, and please join me in thanking our judges. Wow, we covered a lot of great material. That was